Thank you, Chairman. And Chris is tough to follow. That was a good flourish at the end. Judge, congratulations on your nomination. Thanks for spending time in my office with me. Congratulations to your daughters and your family more broadly. This is a big day for lots of folks in your family. Today, the Senate takes up our constitutional duty to advise the President on his nominee to the Supreme Court. The Senate's advice and consent clause and our role is especially important these days when we all, Republicans and Democrats, agree that the 9 justices of the court exercise a lot of power over policy decisions, surely much, much more power than our Constitution's framers ever anticipated. So let's talk about how we got into this mess. We're here in part because of decades and decades of recklessness by all 3 branches, not just one, but by all 3. Congress, the Article I branch, fails to carry out our tasks responsibly and regularly. Rather than make tough policy choices, we pass incredibly vague laws and then just push the details on down Pennsylvania Avenue to unelected bureaucrats in the Article II branch. Then the head of the executive branch, meanwhile, whichever party he or she comes from, grabs more and more power with their pens and their phones. And finally, the Supreme Court, at the top of Article III, tends to overstep the bounds that the Constitution sets on judicial power. The court has ignored restrictions on its authority, inserting itself into policy debates that are supposed to be entrusted exclusively to the 2 political branches. And what do we mean by that? What do we mean when we say Articles 1 and 2 are political? It means that the people are in power over Articles 1 and 2, but not in the long term over Article 3. The men and women in Article 1 and Article 2 are supposed to be answering directly to the American people, and importantly, the American people get to hire us or get to fire us every 2, 4, or 6 years. But rather than honor the roles given to each branch, activist judges usurp the powers given to Articles 1 and 2, which Articles 1 and 2 were complicit in this overreach. Many years of corroding our constitutional order have contributed to the polarization and the viciousness that are poisoning our politics more broadly. We all know that our civic health and our civic life is not healthy, and as was mentioned at the beginning of the hearing, it's at least good that this one got kicked off without a bunch of yokels having to be arrested and carried from the room. When Chairman Grassley tried to speak a couple years ago at one of these, it took like an hour to get started. That kind of nonsense, the theatrics that happen at these hearings, are because of a broader problem. As textualists and originalists have sought to return the court to its historic role, the Supreme Court nomination process has been increasingly punctuated with not just those theatrics, but also with lots of personal attacks. That's not what this process is supposed to be. This process is supposed to be a careful, thorough investigation of a nominee's record to help the Senate make an informed decision on a nominee's fitness for a lifetime appointment. That's why these hearings are supposed to be different, not because people act like jackwagons, but because the people before us, nominated by the president, are potentially going to serve for a lifetime. That office, as Supreme Court Justice, is incredibly important, yet it's also carefully circumscribed precisely because it's a lifetime responsibility. But we know that it's been a long time since this process has worked like that. Instead, this is often a staging ground for nasty, evidence-free personal attacks. We started down this road of character assassination in the 1980s with Judge Bork's hearings, and senators have been engaged in disgusting theatrics ever since. The most recent Supreme Court nominee was subjected to repeated accusations that were nothing more than unfiltered religious bigotry against her. The nominee before her was accused of serial rape, aided by members of this committee. If this process were conducted in good faith, Miguel Estrada and Janice Rogers Brown might well be on the Supreme Court today, but their opponents lied and bullied rather than accepted principled minority judges. We've gotten so used to this kind of bullying that 2 years ago, the current Senate Majority Leader stood on the steps of the United States Capitol and screamed threats against 2 sitting justices of the Supreme Court that they would, quote, reap the whirlwind if they ruled in a way that didn't align with Chuck Schumer's political preferences. That's weird. We should all be able to pause and say, that's weird. That kind of behavior shouldn't happen. This process is broken, but it's a product of a broader brokenness in the erosion of our constitutional structure. A lot of people are willing to take a sledgehammer to the structure if it offers them a quick political win, and it's no coincidence that as more of us embrace an ends justifies the means philosophy of our jobs, which are supposed to be jobs of public trust, our politics becomes uglier, more brutal, and more pathological. Well, we have an opportunity today to do something different, and we can demonstrate that the Congress can carry out its constitutional duty responsibly without a lot of that past ugliness. Judge Jackson has served for the last 9 months on the prestigious U.S. Circuit Court of Appeals for the D.C. Circuit, and before that, you spent 8 years on the D.C. District Court. She has a long record of public service and a long roster of colleagues and friends who will testify to her professionalism. The President believes that she should have a lifetime seat on the Supreme Court, and it's the job of this body to evaluate that recommendation on its merits. So what should we be looking for? We should start with judicial philosophy. The Senate should have a good sense of the principles that will guide a nominee's decision-making on the bench. A robust and thorough judicial philosophy can help us understand how, when faced with difficult or unprecedented decisions, as the court occasionally is, and I would just like to compliment Senator Coons a minute ago mentioning that a huge share of decisions that come out of the Supreme Court are actually 9-0. They just tend to not be the ones that make the headlines, but they're incredibly important. And the public trust that we need to restore in all three branches of government would be well served by us paying more attention to some of those 9-0 decisions. But the ones that tend to be most contentious and the ones that tend to generate the most headlines are the occasions where judges have to figure out what they do in areas which are gray and ambiguous, where the law might not be clear. And so it's incredibly important for a judge to tell us how she or he works out those principles in times that are new and confusing. This will make their rulings more durable and sound, and it will help rebuild public trust in the court and in the government more generally. Unfortunately, too many of the court's decisions do not rest on solid constitutional foundations and reliable legal reasoning. Justices have too often written decisions to claim partisan policy victories and then retrofit bad legal reasoning or political decision-making to justify that ruling. Some of the most divisive cases in the court's recent history fit that bill. It's for that reason that, while we should all respect the Ginsburg rule, the idea that judges sitting before this panel should not weigh in on hypothetical cases that are likely to come before the court, nominees do nonetheless have a duty to be very clear about their judicial philosophy, their legal views, and their interpretive principles. The American people should not be asked to consent to any nominee who operates on principles that are obscure, confused, or concealed. That means that each of us has a job to do in these hearings. It is our job on the Senate Judiciary Committee to ask questions that help give the American people a clear view of the nominee. It's Judge Jackson's job to make her philosophy clear and well understood. And at the end of a constructive hearing, a nominee will have given us a good sense of how she thinks about the constitutional structure, what it does and doesn't do, and the key pillars that support it, most fundamentally the separation of powers and our carefully calibrated system of checks and balances. Throughout this process, we should all remember that a Supreme Court justice is not a lawmaker by another name. A Supreme Court justice performs a crucial but limited function in our political system, namely to interpret and fairly apply the text of the law as written and as understood at the time it was adopted. A forthcoming nominee will make clear a commitment to uphold that purpose, which is the court's true purpose, not the purpose concocted for it by decades of political use, abuse, and overreach. A good nominee will show a commitment to the strict protection of enumerated rights, not the fabrication of unenumerated rights through contorted readings. An excellent nominee will offer a robust judicial philosophy that makes sound decisions more likely and more trusted by the public. Chairman, I look forward to hearing from Judge Jackson this coming week.
Thanks, Senator Sasse. Senator Blumenthal of Connecticut.
Thanks, Mr. Chairman. Good afternoon, Judge,